Hello, and thank you for listening to this podcast. My name is Karen Killaley. I am a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. As always, before we start with today's subject, if you are listening in from your usual podcast app, you'll find any resource documents and speaker information in the description. If you've clicked on the media player link, which was sent to you by email, then you can find this information in the notes section. This podcast contains a general overview of agency worker rights and employer-hirer obligations from an Irish employment law perspective. And we are presenting this podcast to help illustrate some issues that may be of interest to clients and employers in Ireland. It does not constitute legal advice. And as always, if you have a specific situation or question, please do seek tailored legal advice. And last but not least, please don't forget to subscribe on Apple Podcasts, Spotify, or Google Podcasts so that you get a notification every time we create a new podcast. Okay, so I'm joined today again by Kieran Longig, who's an associate on the employment team here at Maples. And today we are going to take a closer look at the law governing agency workers in Ireland. So it's an area that continues to generate questions from our clients, certainly in our experience, particularly around the precise obligations that hirers, so this sort of end user hirer has, and the employment agencies. Typically, those questions can be around sort of working conditions. What are agency workers entitled to? What happens if it goes wrong? What are the enforcement mechanisms available? So we're going to take a walk through all of that. And what we might do is start perhaps with a high level overview of the agency workers' legal landscape. So just by way of very brief introduction, the laws governing the use of agency workers and their rights and the obligations of hirers and the agency and so forth, all of those laws are in place for about 15 years now. And I think we probably would say in our experience that it doesn't tend to be a very controversial area. And I would probably add that in our experience, the use of agency workers by employers can sometimes come into maybe particularly sharp focused in two situations. One, I think, is where the end user, so that the hirer is perhaps involved maybe in a transaction, an acquisition or a disposal. And so there tends to be a little more of a light shone on the type of working arrangements that a business uses. And I think the second place that we would probably see some focus on agency workers is when a more localized, shall we say, dispute arises. So perhaps around inequality of working conditions and sometimes in relation to the termination of an agency worker. So there are a couple of the situations. Ciara, we're going to talk through all of those in a minute, but maybe let's just start off with a brief summary of the various pieces of legislation in addition to that 2012 Act that govern agency workers in Ireland.
Yes, absolutely. So the primary piece of legislation, as you mentioned, is nearly 15 years old at this stage. It is the Protection of Employees Temporary Agency Work Act from 2012, which transposed the EU Temporary Agency Work Directive into Irish law. This is the act that establishes the principle of equal treatment for agency workers in respect of basic working and employment conditions. Alongside that, we also have the Employment Agency Act from 1971, which deals with the regulation and licensing of employment agencies themselves. So you have two complementary regimes, one focused on protecting the workers and one focused on regulating the agencies that place these individuals in certain entities. These sit alongside general employment protection legislation, so agency workers also benefit from protections under statute like the Organisation of Working Time Act 1997, the National Minimum Wage Act from 2000, and the health and safety legislation, depending on the nature of the engagement. And we'll discuss that point a little bit later in more detail.
Yes, absolutely. And I think that helps to sort of showcase that agency workers are not sort of over there as an entirely different category of worker, actually on the basis of the legislation that now governs how hirers use agency workers, you really need to think very carefully about how those agency workers are treated. So maybe a good starting point is to dive into the 2012 Act in a little bit more detail. And I suppose let's maybe, if you want to talk through, like, first of all, what is that Act trying to achieve and what are the key obligations that it creates for, I'm going to say employers, but really we mean hirers who are based in Ireland?
Yes, well, at its core, the 2012 Act is about ensuring that agency workers are not treated less favourably than comparable direct employees of the hirer. So the central principle is one of equal treatment from day one of an assignment. An agency worker is entitled to the basic working and employment conditions as if they have been directly recruited by the hirer to occupy the same job. And it's worth noting that unlike some other European countries, there's no qualifying period in Ireland. In the UK, for example, agency workers must complete a 12-week qualifying period in the same job with the same hirer before full equal treatment applies. Here, those rights apply from day one of the assignment. The obligations fall on both the hirer and the employment agency. So the hirer must provide equal treatment in respect of basic working conditions and employment conditions, and must inform agency workers of any vacancies that arise. The agency, meanwhile, must not impose restrictions on the agency workers taking up employment with the hirer after the assignment ends. Anti-poaching clauses are void under Section 12 of the 2012 Act. The agency also cannot charge the worker a fee for arrangements connected with their being employed by the hirer after the assignment, and that's in fact a criminal offence under Section 13 of the 2012 Act. And importantly, under Section 15 of the Act, the hirer has a duty to provide the agency with all information it reasonably requires to comply with the Act. If the hirer fails to provide correct information and the agency is found to have contravened the Act as a result, the hirer must indemnify the agency for any loss incurred. So that's a real incentive for hirers to really get this right.
Yes, absolutely, for sure. Thanks for that. Okay, so look, maybe let's look at who is covered by the 2012 Act. And even before we get to that, probably if you could just give a couple of practical examples of the type of, I suppose, the type of work that agency workers do. What does it actually look like? What do we see in practice?
Yes, absolutely. So temporary agency workers can be of benefit to employers for many reasons. They might be engaged for specific projects. Say a company is rolling out a new IT system and needs additional support for a period of 6 months, or they might be brought in to cover periods of seasonal or exceptional busyness, to cover maternity leave or other absences, or simply to meet a temporary need without committing to a lengthy recruitment process. From the worker's perspective, agency work often offers flexibility and the opportunity to develop skills and accumulate experience across different employers and sectors. In terms of the legal framework, the Act applies to agency workers temporarily assigned by the agency worker to work for and under the direction of a hirer. You need that triangular relationship. The worker has a contract of employment with the agency has a separate commercial arrangement with the hirer, and the worker goes to the hirer's premises and works under the hirer's direction and control. So taking that project example, if a company engages an agency to provide 3 additional engineers for a 6-month systems implementation, those engineers are agency workers employed by the agency, but working day to day under the direction of the hirer.
Perfect. And we'll distinguish that from some of the other situations that are excluded. So the Act does specifically exclude certain types of working arrangements. So, for example, an agency worker does not include like a self-employed person or an independent contractor who is introduced by an agency to a hirer. So that's not within the scope of the Act. Or sort of B2B arrangements where the hirer is simply a client or a customer of another business. Another exclusion is placement services, where the agency introduces a worker for direct employment by the employer, so sort of executive search type functions. Another piece that requires a little bit of care and attention to analyse is the managed service contracts exclusion. It's not always obvious when a managed service contract, in fact, fits within that exclusion. And basically, this exclusion relates to where workers are provided by another entity and those workers are actually operating under the supervision and direction of their employer rather than that of the hirer as such. Finally, there are some other exclusions provided for under the Act, and that includes certain publicly funded work placement schemes. So, always worth looking to make sure that the worker in question is an agency worker and that they don't actually fit into one of those sort of 4 or 5 exclusions we just touched on there. So, Kira, I don't know if there's anything you want to add to that in terms of assisting employers in Ireland to distinguish these workers.
Yes, and you touched on it there. I mean, one of the key distinguishing features are direction and control. So if the worker is on site but taking direction from their own employer rather than from the hirer, it's likely a managed service arrangement is in place, and that falls outside the scope of the Act, as you mentioned. But if the hirer is directing and supervising the work, i.e., telling them what to do, how to do it, when to be there, then there is a risk that the 2012 Act may actually apply. This is a point that commonly arises in practice, as you mentioned, and it's a question which can arise as to whether the individuals are engaged under a managed service arrangement or are they actually in fact agency workers for the purposes of the Act.
Yes. And who is the employer in inverted commas in this sort of triangular arrangement between agency, hirer, and worker?
Well, it is a very good question and it depends on the context. So, for equal treatment on basic working conditions, the hirer carries the primary obligation. But for other purposes, say, for example, payment of wages, provision of statement of terms under the Terms of Employment Information Act, the agency is the employer. And importantly, under Section 13 of the Unfair Dismissals Amendment Act 1993, the hirer, not the agency, is deemed to be the employer for the purposes of unfair dismissal claims. So where the agency worker is dismissed, it is the hirer who is liable. That sometimes catches hirers by surprise. One more important point to note. I mentioned that the hirer's obligation is to provide equal treatment on pay and basic working conditions, and that is the equal treatment principle under the 2012 Act. But listeners should distinguish this from the employment equality obligations under the Employment Equality Acts. Crucially, when it comes to discrimination claims under the Equality Acts, either the agency or the hirer can be liable. And the question will be who is responsible for the alleged discriminatory act. In some cases, it may be both.
Yes, absolutely. That's a really important distinction. And it is, in fact, a point which arises often before the WRC, as in who is the correct respondent in respect of an individual's claim. Okay, well, look, again, another reason just to be very clear in terms of the correct status of workers who are currently performing services and establishing whether or not a worker is in fact an agency worker is really important because it triggers those obligations you've just talked about. And we're also going to talk about something else that's important, and that is the Swedish derogation. Can you just explain what that is? What's the significance of that and what is it?
Yes, absolutely. So, pursuant to Section 6.2 of the 2012 Act, the equal treatment principle in relation to pay will not apply to agency workers who are employed under a permanent contract of employment with the agency, so long as certain conditions are satisfied. This exemption may apply provided two conditions are met. Firstly, the agency must notify the worker in writing before they enter into that contract that the equal pay principle will not apply. And secondly, in between assignments, the agency worker must be paid at least half of what they were paid on their last assignment, and that amount must not be less than the national minimum wage. The derogation is limited to pay only, so it does not disapply the agency worker's entitlement to equal treatment in respect of other basic working and employment conditions. From a practical perspective, the important point to note is that Irish hirers or employment agencies should not assume that using the agency automatically avoids equal pay obligations. The derogation is a narrow exception and depends on the agency worker's contractual stays and the payment arrangements between assignments.
That's great. Thanks, Kira. So, turning to the working conditions that you've already talked about, what does equal treatment mean in practice?
Well, basic working and employment conditions are defined in Section 2 of the 2012 Act. It covers pay, working time, rest periods, rest breaks during the working day, night work, overtime, annual leave, and public holidays. So it is a broad definition. Pay is defined as basic pay and any pay in excess of basic pay in respect of shift work, piecework, overtime, unsocial hours worked, or hours worked on a Sunday. Importantly, it does not include sick pay, pension payments, or financial participation schemes. In practice, the hirer needs to identify the appropriate comparator. So the question is, what would this worker be paid and what conditions would they enjoy if they had been directly recruited? The agency worker is entitled to no less favourable treatment from day one, as we mentioned. Section 14 of the 2012 Act also requires that agency workers are given access to collective facilities and amenities, so things like canteen, childcare, transport services, on the same basis as directly employed workers, unless the difference in treatment can be justified on objective grounds. This is actually the only section of the Act which allows for objective justification. There is very useful WRC guidance which confirms that cost alone is not an acceptable objective justification, and it must be based on practical or organisational considerations. Looking then at Section 7 of the 2012 Act, this section contains anti-avoidance provisions to prevent the use of successive short assignments to circumvent the 2012 Act. Assignments with the same hirer, same worker, same place, and same or similar work are treated as a single assignment, but any break of longer than 3 months between assignments resets the clock.
Perfect. Thanks for that. And just in terms of penalisation, it's worth noting that the 2012 Act contains two separate provisions governing penalisation. First of all, Section 23, that prohibits the employer from penalising the agency worker, and Section 24, which prohibits the hirer, so the end user, from penalising the agency worker. And as is consistent with other pieces of employment legislation, which many listeners will be familiar with, penalisation includes issues such as dismissal or demotion or transfer of duties, change of working hours, imposition of any disciplinary penalty, coercion, intimidation. So really a broad sort of church of adverse treatment, and anything which really, if you like, acts to the detriment of the agency worker in response to them invoking their rights under the Act. The WRC guidance, which you just mentioned, also notes that the fact, I suppose, that temporary agency workers will need to occasionally change location, change duties, and be somewhat flexible, that context of work needs to be taken into consideration when assessing penalisation, and that indeed sounds sensible. So in other words, the parties should acknowledge that the very nature of agency work is such that it does sort of change from time to time in terms of hours and location and the breadth of duties and so forth. But where a change is adverse and it's linked to the assertion of a right, it can constitute penalisation. So agency workers can file a claim as like any other employee or former employee with the WRC within 6 months of the event giving rise to the cause of action, and an adjudication officer ultimately can award an agency worker compensation of up to 2 years remuneration, or they can order reinstatement or re-engagement where they find that the agency workers' rights have been breached. Okay, so we've talked a little bit about who agency workers are, what they do, broadly what the obligations are of the agency and what the obligations are of the hirer. So maybe let's talk a little bit about what happens in practice, and no better way to do that than to look at some recent, well, actually not so recent case law. You're going to talk to us about Stafford and Isaacson. So this is a Labour Court decision from 2014. What does this case tell us?
Yes, and while the case is from quite a number of years ago, it remains quite relevant today in terms of the use of comparators in these types of claims. In terms of background, this case revolved around a group of 14 agency workers, which included drivers, general operatives, and assistant foremen, who were assigned to Cronin Movers Group. These workers claimed that they were being paid less than directly employed workers doing the same work. The agency drivers were being paid €11 per hour, while directly employed drivers were receiving €13.19. The agency argued that the higher rates were historical legacy rates and that the hirer would have paid lower rates had it recruited around 5th of December 2011, which was the relevant date. It pointed to two workers recruited on the lower rates. The Labour Court, however, rejected that argument. On the facts, it found that those two workers did not actually occupy the same jobs as the complainants. But more fundamentally, the court held that the agency workers are entitled to the rate that applies generally to directly employed workers occupying the same job, not a notional or hypothetical rate. The court said that to consider a hypothetical rate would undermine the principle of equal treatment and defeat the purpose of the directive and of the Act. The court also held that cost alone cannot compromise a fundamental right set out in European law and cited CJEU authority, and that the burden of proof falls on the party asserting a different rate should apply. So there are three key points to take away from this decision. I suppose the first being you cannot substitute a hypothetical rate for the actual going rate. Secondly, cost is not a defence to equal treatment. And finally, hirers must provide accurate information about what their directly employed workers are actually being paid, because in this case, the hirer's information was essentially self-serving and did not reflect the reality.
Okay, thanks, Kira. That's a really interesting case, and it's great to have all of those principles encapsulated in one decision. You do have another one that you're going to talk through with us, and this is a much more recent decision, 2023 reported decision in Sheehan versus Boston Scientific, and that started off before an adjudication officer and wound up before the Labour Court on appeal. And this raises, as I understand it, a really important point about continuity of service when an agency worker transitions to direct employment with the hirer. Do you want to talk through this?
Yes, absolutely. So in this case, Mr. Sheehan worked as a product builder at Boston Scientific's plant in Cork. He was placed there through Kelly Services from July 2017 for approximately 23 months, then transitioned seamlessly to a permanent contract with Boston Scientific in July 2019. Same workplace, same role, same direction and control. He hadn't resigned from Kelly's, hadn't applied or interviewed for the Boston role, and he was subsequently dismissed in January 2020 during his probation period for attendance issues. So the first question which arose was whether he had 12 months continuous service in order to bring an unfair dismissal claim. Mr. Sheehan's direct hire service with Boston Scientific was only about 6 months. He needed to argue that his prior agency service should count towards the 12-month threshold. He relied on Section 13 of the Unfair Dismissal Amendment Act 1993, as I mentioned, which deems an agency worker to be an employee of a third-party hirer for the purposes of the Unfair Dismissals Act. Looking at how the WRC handled that question, interestingly, the WRC adjudication officer found in favour of Mr. Sheehan. She looked at the reality of the employment relationship and found that Mr. Sheehan had been under the direction and control of Boston Scientific the entire time. She drew on the UK Court of Appeal approach in Dacus versus Brook Street Bureau, the Labour Court analysis in Diago versus Rooney, and the High Court decision in Board of Management Community School versus Connaughty, which dealt with the concept of an informed waiver of acquired rights. She found that Mr. Sheehan was hopelessly unaware of his pre-existing unfair dismissal protection as an agency worker and had not made an informed waiver of those rights on transition. So she concluded that his service ran from July 2017, and she found the dismissal to be unfair both substantively and procedurally, and ordered re-engagement, interestingly.
Okay, but that was not the end of the matter. Boston Scientific appealed to the Labour Court. Do you want to just talk us through what happened there?
They did, and the Labour Court overturned the WRC decision on the preliminary issue of continuity. So the Labour Court followed its earlier Hewlett-Packard decision and held that the purpose and effect of Section 13 of the Unfair Dismissal Amendment Act 1993 is to create certainty in relation to liability and employment status for the purposes of the Unfair Dismissals Acts in respect of a dismissal occurring while someone is employed by an employment agency and assigned to a third party. Crucially, the Labour Court held that Section 13 does not have general application for the purposes of computing service following the termination of the contract with the employment agency and in respect of a dismissal occurring during the currency of a subsequent contract of employment with another employer and under another contract of employment. So in other words, Section 13 protects agency workers from unfair dismissal during their assignment, but it does not operate to create continuity of service where an agency worker subsequently becomes a direct employee of the hirer. The court also had regard to the first schedule of the Minimum Notice and Terms of Employment Act 1973, which provides that service is deemed to be continuous unless terminated by dismissal or the employee voluntarily leaves the organisation. So the court found that Mr. Sheehan's agency contract had come to an end and a new separate contract with Boston Scientific had commenced where there were two distinct employments.
That's very helpful, thanks. So the Labour Court's position is clear on this. The clock resets effectively when an agency worker moves to direct employment.
Yes, exactly. It's a welcome restatement of the law from the employer's perspective, and it confirms the limits of Section 13. The agency assignment and the direct hire are treated as separate employments for the purposes of calculating continuity of service under the Unfair Dismissals Act.
Okay, that's great. All very clear. I think there are probably 2 or 3 principles for hirers, so end user hirers in Ireland from this case. Do you want to recap on those?
Yes, absolutely. There's real value in examining the details of this case. So even though the law was on the employer's side here, this case generated years of costly litigation. The Labour Court expressly noted that organisations should maintain a clear distinction between an agency worker's assignment and any subsequent direct employment. That means clear oral and written communications with the worker at the point of transition, documenting that the agency contract is ending and that a new separate employment relationship is commencing and that service does not carry over, which is very important in practical terms because this is something that does come up from time to time. Secondly, even where an employer believes a worker lacks unfair dismissal protection, because they are within probation, principles of fair procedures and natural justice still apply, particularly where misconduct is alleged. The WRC was critical of the process in this case, and even though the Labour Court overturned the decision on the jurisdictional point, no employer wants to be in a position where their process is found wanting. And then finally, the document retention point remains relevant. So the WRC adjudication officer drew adverse inferences from the destruction of key witness statements during the life of the complaint. The employers in general need to be vigilant about preserving relevant documents once any statutory complaint or litigation is in contemplation.
Yes, absolutely. They're sort of broadly applicable to employers in Ireland in any event. And just in relation to the second point that you mentioned there, we have previously prepared podcasts about the application of fair procedures and natural justice to allegations of misconduct. So we would encourage listeners to seek that out. We will also put a copy of the 2012 Act and those 2 decisions, the Sheehan decision and the Isaacson decision that you've just talked about there, Ciara, into the show notes as well. So look, we hope that you found the information that we've provided here today to be useful and helpful. For now, thank you for listening to the Maples Group Irish Employment Law Podcast. As always, if you have any questions or queries on any of the points covered today or on employment legal issues in Ireland generally, please do get in touch with us. Thanks for listening and subscribing.